of exercise of executive power there is this? This is a mockery. Democracies work, and this is much worse. You assume something that doesn't exist. Independent of 367 cannot be done.
Why?
Because you are only acting as the legislature. You don't have any powers independent of the legislature under 356. That's Bomai has held that. Well, may I, with your 2 minutes, I'll take. There is a speech by M.A. Beg, Afzal Beg. Just it will take only.
Just give us just the page and the gist of it. You can tell us.
It's 694 PDF 694. It's only temporariness of the article. That's why that's the last person. You need not go through it. It refers to the temporary nature of the article.
It would be in the same vein as Mir Qasim's speech at 648.
And Mullahs, kindly note this: he was a representative of Jammu and Kashmir in India's Constituent Assembly. There were 3 members total. He was one of them. So he was part of the Constituent Assembly of India as well, of Jammu and Kashmir. And references to the government of the state shall be construed as including references to the governor of Jammu and Kashmir acting on the advice of the Council of Ministers. How can that be? There is no Council of Ministers. So you create a constitutional myth. And assume in the absence of Council of Ministers that there is a Council of Ministers. And then you pass a presidential order that even in the absence of Council of Ministers, the governor is acting on the aid and advice of the Council of Ministers. What kind of exercise of executive power there is this? This is a mockery. Which is why I've been saying it's only a political act. It's not a constitutional act. You wanted to do something, you did it. D is even more serious. I don't think in any constitutional democracy in the world this has happened. In the famous Miller case in the UK, Malaj, Boris Johnson tried to bypass Parliament and requested the Queen to prorogue the House. The House was prorogued. Immediately, Malaj, matter came to the Supreme Court. All the justices of the court sat. Now, Malaj, your Lordship knows this is the executive power of the government. They can prorogue the House. But all came to a unanimous decision. You cannot even prorogue the House like this. You cannot exercise executive power to bypass Parliament. You bypass discussion in Parliament. That's not the way constitutional democracies work. And this is much worse. You assume something that doesn't exist. You give powers to the governor, which he does not have. You assume to yourself under 350 all the powers of the state legislature. You are Parliament, so you therefore invoke the powers of the state legislature and Parliament, and you pass an executive order. What kind of exercise of law is that, or constitutional law? And then D, in the proviso to clause 3 of Article 370 of this Constitution, the expression Constituent Assembly of the state referred to in clause 2 shall be the Legislative Assembly of the state. What power does the President have to pass such an order? We're not dealing here with exercise of constitutional power. We're dealing with exercise of executive power.
Just as a test, from their perspective, why was the amendment to 367 necessary at all? Why was this crucial? I mean, we are seeing now the modalities which they have put into place. For their constitutional design of ultimately abrogating 370, why was this amendment to 367 necessary?
Because, brothers, they themselves gave the power of the Legislative Assembly, which they were exercising in 356 as the Constituent Assembly, and recommended. They were ad
Normally
item with
when
my
a-
interpretation.
Yes,
They were ad item with my interpretation.
right.
That you needed the recommendation of the Constituent Assembly. So
They
how do you
constitute-
reach there?
They constituted the Legislative Assembly as the Constituent Assembly.
And Malad, what they do is they don't interpret it. They say in Proviso 3 of 370, the expression Constituent Assembly of the state referred to in clause 3 shall read as Legislative Assembly. So they have amended Article 370 of the Constitution. Shall
Actually,
read as.
367 amendment was not required because you are exercising
Was.
power under clause 1 to say article.
No, it was required because you needed the recommendation of the Constituent
No,
Assembly.
no, that's something separate. But in 367, introducing clause 4, in terms of the notification dated 5th August 2019,
You required it because Malad, they changed the definition of Constituent Assembly in 370 as Legislative Assembly. This is why they could exercise power under 356. Please appreciate.
But suppose for a moment that they had not gone through this exercise of amending 367, all right, or introducing 367(4), and suppose we are operating purely within the fold of 356.
Yes,
All right, your challenge to the 356 notification is a different issue.
yes.
You're now just testing it as an exercise of power under
Very-
356.
very well.
Once a proclamation takes place under 356, two consequences follow. One, the president assumes to herself all the powers of the state, the executive powers of the state vest in the president. Two, except the legislature, the powers of the state legislature. Two, the powers of the state legislature are then subsumed in parliament. The government of India does not in its executive capacity exercise the powers of the state legislature. Parliament has to exercise the powers. So once the proclamation under 356 was issued, two consequences would follow. All the powers which were vested in the executive of Jammu and Kashmir were transferred to the president.
Correct.
All the powers of the state legislature were vested in parliament.
Right.
Now, if that was so, then if 370(3) is capable of the interpretation, just as a hypothesis, that it's a power to be exercised by the president to abrogate. They abrogate. Point number 2, any powers which were to be exercised by the state legislature would have to be exercised by parliament, so they had to go to parliament to get a resolution passed. Why was 367 necessary for the design, for the constitutional design to achieve this at all?
I tell you, 356 power cannot be exercised by parliament, by the governor, by the president and parliament in this fashion. Independent of 367, cannot be done.
Why?
Because you are only acting as the legislature. You don't have any powers independent of the legislature under 356. That's, Bomai has held that. You have no such powers. And the executive is only dealing with administration. It can't amend the constitution under 356. Therefore, they had to do this. There was no choice. I'll show Manas Bomai.
Yes, but assuming for a moment that we suppose we disregard the 367 amendment.
Even if you do, then you can't exercise it under 356 at all. That's even Manas, it will be a dead letter. It will be inchoate. Because you can't amend constitutional provisions, Manas, through 356. You can only exercise the power of the state. Parliament can do it.
Fair enough.